Hello and welcome to this Health Plus Law webinar. My name's Dion Kagan and I'm a Research Associate at the Faculty of Law and Justice at the University of New South Wales and a research team member at the Health Plus Law Partnership. In today's session, we're going to introduce and discuss a new report we recently published here at Health Plus Law, which maps the legal environment surrounding HIV in Australia and identifies some of the key areas of legal concern surrounding HIV. This is the first of two linked webinars, and in the second, we'll be discussing a similar review which mapped hepatitis B and the law. I'm going to be talking about these reviews with my colleague, Dr. David Carter. Hello, David.
Hi, Dan.
David is a Scientia Associate Professor at the Faculty of Law and Justice here at UNSW. And he is the research lead at the Health and Law Partnership. And he's also the lead author of this report, which is called HIV and the Law in Australia, a mapping review of contemporary case law. Now, we're going to get into the guts of this report in a minute, but I thought a good place to start would be to talk a little bit about the broader aims of our research and where this particular review fits into it, and just establish a little bit of the context for what we were aiming to do here. So Health Plus Law was established to work on addressing legal barriers to testing and treatment for people living with hepatitis B or HIV in Australia. And one of our guiding concepts, which we talk about a lot in our work, is this idea of the enabling legal environment for people living with bloodborne viruses. And I just wanted to start, David, by unpacking that concept a little bit. What do we mean by an enabling legal environment, and what are some of the things that we're doing at Health Plus Law in that area?
Yeah, look, thanks, Dion, and thank you for that introduction. Look, the enabling legal environment is a concept or a term that's been used really for a long time, particularly in the HIV sector, but also in the viral hepatitis sector in relation to hepatitis B and C. And the idea is that we want to recognise that law has this role to play in contributing positive pressures and towards positive health outcomes for people living with a bloodborne virus, including HIV. But it can also, of course, generate injustice. It can form barriers to good health through discrimination or failing to properly regulate discrimination, criminalisation, or other burdens that are placed on individuals and indeed on health systems and social groups. And so the idea of an enabling legal environment recognises that we all exist in this environment, which is made up of laws and regulations and legal practices and legal institutions. In a way, law is kind of everywhere. And if we can understand a little bit about the current state, the future state that we want of that environment, what we hope to be able to do is to not just assess what's going on in terms of what the law might be creating, but also that we can ameliorate or reduce any of the negative health impacts, the negative human rights impacts, the injustices that law and legal practices can generate, but also potentially to use law as a tool to advance the interests and health and fair treatment of people living with a communicable disease. And so this legal environment as a whole, what we call an enabling legal environment, is really important, I think, particularly for conditions like HIV, because it helps us understand how our systems are working and what law can contribute to enabling good quality testing, treatment, and health generally, as well as supporting people to achieve the kind of quality of life outcomes and other aims that are really important outside of health directly. So that's what the enabling legal environment is. It's a really important concept in this world, and it's something that we are using always to kind of orientate our work.
Okay, yeah. So everything we do is sort of focused on this, on the legal environment and on making it more enabling, I guess. And so a big part of our goals, and this report fits into it, is to understand how the environment is currently working, where the law is being supportive, and where it's obstructing in some ways good health outcomes, and to therefore be able to really pinpoint and identify areas where there might be potential legal and policy reform. And so this report, which we'll get to in a second, I just want to ask one more sort of framing question. It sits, this work more broadly in a history of what people have called legal environment assessments, or LEAs, and these have quite a long history, particularly in HIV public health, and in the sort of legal response around HIV. So just before we get into this report, can you say a little bit about legal environment assessments?
Yeah, look, you're right. There's a long history of legal environment assessments, particularly in HIV. It goes back, many decades. And what we're doing and talking about today in terms of this report forms part of a kind of legal environment assessment for HIV in Australia. I think the way I think about legal environment assessments is that community members, particularly their loved ones, their kin and family, clinicians, community service workers, peers, and others who work in and around and who are affected by HIV usually have a pretty strong understanding of the legal environment within which they work and its effects on themselves and those around them. And a legal environment assessment is a way, I think, of formalising some of that assessment with the benefit of that lived experience, with the benefit of kind of technical legal expertise, with a view towards, as you said, kind of policy and law reform. And it's a process which involves having a number of conversations, a number of different pieces of data that come together at some point to say, look, how are we doing at the moment in relation to the law and HIV, or indeed what's the health and how enabling is our legal environment around HIV? And this can be a process that takes quite a long time. The report we're going to talk to today is a preliminary part of that assessment, but not the whole thing. Most importantly, legal environment assessments need to be revisited over time as well, because as many people watching this will know, particularly in relation to HIV, there has been phenomenal and massive change biomedically, socially, and legally since the last time something like a legal environment assessment was undertaken in Australia, which was in about 1992, with the work of the Intergovernmental Committee on AIDS and a very, very large legal environment assessment. Our piece today is one of the preliminary pieces. We call it a legal mapping review, and that really is about focusing particularly on the kind of formal disputes and challenges and issues that get taken up into tribunals and courts, to learn about what's happening, at least in that part of the law. Obviously, it leaves out a lot of other parts. It leaves out the lived experience of it in particular, but it does give us a really clear understanding of the kind of legal situations that HIV brings up and that gets taken into formal dispute resolution through courts and tribunals. But it also tells us about the kind of main areas of law that are kind of currently active in relation to HIV that are producing these disputes. It gives us some sense also about how these things impact on individuals, and all of that together then gets taken up into this larger process of assessing how enabling or not the legal environment is around HIV.
Yeah, okay. So a review of this type is taking the existing cases where judgments or decisions have been made, and there's a legal record of them, to start to sort of sketch a map of the legal environment surrounding HIV and how it impacts people living with HIV. But it's not the whole picture of the law. So as you just implied, that there's lots of things that get left out. Can you talk a little bit more about what the limitations, I guess, of this kind of legal mapping are? I mean, what it's sort of aiming to do, but also how it's limited and why it's only a part of the legal environment assessment that we're working on more broadly.
Yeah, look, it's important. Certainly does have limitations, but they're useful to know about, and once you know about them, you have a sense of what this is. So, I mean, number one, a legal mapping review is looking at the legal landscape, the kind of formal legal landscape. It's looking at, as you said, decisions and judgments by tribunals and courts. It's not looking at and can't see all the things that happen, even in those same cases, before we get to a judgment or a decision, which are
Mm,
very important in terms of people's experience and how the law really is experienced on the ground, as it were. In addition, the other thing that it also misses out on, of course, are even disputes, and not every dispute or judgment ends up uh, either reaching a kind of final stage of a judgment or a decision by a decision maker or judge. But again, many of them will never be published, and so not accessible, at least easily, on the public record. So what this does do is it gives us a kind of map of the underlying terrain. It's not a comprehensive and detailed map, but it gives us some sense of it. And like any map, it always is an approximation of the true landscape underneath. And so I think the way to think about this is it tells us and gives us a series of very important signals about what is occurring, at least at that formal level of disputes through courts and tribunals. It also gives us then a kind of bit of a tip, or gives us a little bit of an assessment of where we should go next and what we should ask people about as well. I think that's probably the main thing to keep in mind in terms of what this is and what its limitations are.
So this is work that really sits alongside a lot of other things that we're doing, including talking to people living with HIV, talking to people who work with those people and support them as peers or service workers. A lot of other um, approaches, I guess, to gathering and a sense of you know, what the law, how the law is functioning. So, with a review like this, one thing I learned in my contribution to it is that a lot of decisions have to be made for how you process and manage the data. What records are to be included, cases where HIV is relevant, or whether it's just a sort of passing reference, and in those those examples that those get excluded. So lots of decisions that get made about selection strategy, search strategy, then how to store that data, analyze that data. What are the kind of key elements of these cases that we want to sort of pull out and look at more closely? And I know that we've drawn on some existing tools, existing legal environmental assessment tools developed by the American Bar Association, by the United Nations Development Program, and kind of tailored those to the Australian context, and how HIV manifests in Australia, who the affected communities are here, and so forth. So, partly I wanted to say all that because there is a lot of method here in this type of work.
Well, a lot of methods, a lot of decisions as well, as I think you're indicating. I mean, the the coverage issue is a major one I want to highlight. I
mm,
referenced it earlier, but not every judgment, even of some of the highest courts, is published. That can happen just because of editorial decision making. It can happen because there are really important privacy implications that might occur, particularly in relation to HIV, where it is not uncommon for a judge, particularly, to decide that certainly someone's name may not be published, but indeed maybe the whole judgment might not be published publicly as well. And so, in a way, I think we need to acknowledge that we're working with a particular sample already. It's not every single judgment. I mean, certainly there are very, very few, if any, judgments available from the local court in most states and territories in Australia. But that is, of course, the court that sees the vast bulk of kind of formal legal proceedings occur. And so we're already focused on the kind of appellate, upper, more senior courts in the
mm,
hierarchy. And there's this kind of editorial selection process that goes on. And so one of the things we did, which we thought was useful, and of course, people can read about it in the report itself, is we looked to other sources as well. And this is quite common in the HIV context in particular. There have been some really important pieces of scholarship as well as community resource that has looked at media reporting, for example. And so we looked both at Australian media reporting of HIV-related case law, and also we looked at some specialist services as well. And one of them comes to mind is Legal Link, which was this really fantastic and very detailed quarterly newsletter that was around from 1991, I think, right through to 2001. This was put together by what was then the Australian Federation of AIDS Organisations, FAO, now Health Equity Matters, and indeed kind of led to the formation of the HIV/AIDS Legal Centre, on whose board I'm proud to say I sit, and is a partner on this project. This resource is fantastic. It was for both community activists, community members, and lawyers. And so in its pages, you can read a kind of legal history of HIV and the law over at least that sort of 10-year stretch. And we pulled a lot of cases from that where they were mentioned. So what we've been able to do is to be a little bit open-minded about sources, acknowledging the limitations, particularly the kind of official sources. And so then have drawn on media and kind of specialist legal services in order to kind of try and build, again, this kind of map of the terrain. What we didn't do, be really clear, is because it is kind of not really useful, we didn't kind of go through every single record in every single database. Instead, what we're looking for is to get that clear sense of the map and say, look, there's enough here to tell us roughly what's probably going on in this area of law, and enough here to tell us there's something going on in that area of law. But unlike systematic reviews in the health sciences and medicine, where part of their approach is to be kind of entirely systematic insofar as that is ever possible, that's not as useful for us anymore, because every case turns on its own facts. And so what we've done is look for the main cases and to try to find the main kind of areas of law. It's a lot of results came back. It's not a small number, but that's what we did.
And that's so such an interesting reminder that there are these other sources like Legal Link, which you mentioned, that are linked to, I guess, a more community experience of the law, and the kind of advocacy side or legal advocacy side of this history, of Australian case law, in Australia, and that those are very important sources for the legal record, certainly in the case of this review. I did want to just note for people listening in that if you are interested in those search methods, we have a very rich and detailed description of them in our report on this review, which is, of course, available on our website. So you can read about it in more detail. But I want to move on to this kind of juicier part, which is what our review found, what really came up. I want to say at the beginning is just that HIV appears across the gamut of areas of law, and I'll be interested to hear you, say a few things about what that means. But yeah, what emerged? What is on this map of HIV related case law?
Yeah, look, you're right. It's kind of everywhere, I think, legally speaking, and that's important. And I might speak to that in a second as well. But I think let's start with people living with or affected by HIV. So in our kind of public health and strategic response in Australia, at least, we think about priority populations and priority groups, and this is about identifying particular populations or groups of people who are most affected by HIV or at risk of acquisition. And so one of the things we did was we looked at the participants in these cases or decisions and classified them according to priority populations. Look, there's often not huge amounts of biographical or other detail in some of these cases. So the vast majority of cases fell into the broadest category, which was people affected by HIV. So people living with HIV in particular, in our case. The second highest number of cases that we included, though, were people who were in custodial settings. And so people who were in various forms of detention, imprisonment, or institutionalisation. And we already know, of course, that people who are in custodial settings are already greatly marginalised and, of course, are disproportionately affected by criminalisation, including of HIV. The next largest group, we take a kind of unwieldy title from the HIV national strategy that is just being completed. We have a new strategy coming out shortly, and this is culturally and linguistically diverse people from high HIV prevalence countries. It's really springs to mind, but essentially what we're talking about in our case are people who were born overseas. This is important. We didn't want to assess the kind of prevalence of HIV in a person's country of origin. Sometimes it wasn't clear exactly what the country of origin was. But given our broader research around migration and non-citizens and its interaction with HIV, this is obviously a very important category and group for us. Interestingly, there was, some cases, of course, involving men who have sex with men, but it wasn't, the kind of predominant group that we saw. And again, there are some difficulties really ascertaining some of these matters in some of the cases where the kind of biographical detail might not be on the surface of the judgment. And then there also, of course, was a number of cases involving sex work and those who are sex workers. We, I think, identified 4 cases from memory. Again, of course, the law, and particularly the criminal law, has an outsized and over-the-top role in relation to the sex industry and people who work in the sex industry. But here we're talking about specifically HIV-related cases as a subset of that, just to be clear. So that's why there are, I think, only 4. A couple of other things in brief that are maybe useful is, we thought about jurisdiction as well. About half the cases we collected were heard in a Commonwealth court or tribunal in that jurisdiction. New South Wales, from memory, was the source of most HIV-related cases that we included, followed by the big states of Victoria and Queensland as well, and then South Australia. I think, to your point about stretching across areas of law, that's a really important thing to note for us here. Really, HIV in this case law appears across almost all areas of law insofar as we can classify them. But if we think about kind of top 10 list, then criminal law is still very present, probably the first. The second is migration and refugee law and process, and the third we classified as discrimination law. They're the kind of top areas of law that we dealt with.
I want to ask you about each of those areas of law, but and maybe I will by starting with criminal cases. One of the things that jumped out to me, and this was the so-called spitting and biting cases. Could you say a little bit about those and what are spitting and biting cases?
Yes, so they're a troubling and disappointing part of the law's engagement with HIV. Spitting and biting cases are cases where, in a variety of contexts, someone is alleged to have either spat on or near, or even further away from someone, or indeed have bitten them, where authorities then pursue some kind of criminal prosecutorial process against that person. This is based on the fear, the unscientific, but there's still very active fear of HIV transmission in these cases. These are, unfortunately, they should be none of them, frankly. Unfortunately, there are quite a number of them. And this is despite now many, many years of a very clear medical consensus that HIV cannot be transmitted via contact through spitting or a single bite from someone living with HIV. Yet we found a lot of these, and in particular, we found them in media reporting as a source. And so you can see the kind of link there with the kind of sensationalist media treatment. We tended not to find them in the actual case law published by courts and tribunals. I think that another thing that is worth noting is that we also found that there were prosecutions for people living with HIV for transmission-related offences, which were in, I think, all jurisdictions. Despite the repeal of HIV-specific criminal offences, those prosecutions do continue to occur. And I should note too that we were careful, I think, to kind of pay attention, particularly to the most recent years of these matters. Going back, 30, 40 years is probably useful, but we really made sure that we were looking at the most recent data, and in particular, because of the digitisation of records, more recent data is more readily available, and yet we still found these transmission cases occurring across different states and territories.
And so that sort of reminds me that one of the things a legal map like this can do is track changes over time. And that's really important with HIV because the sort of meaning of an HIV diagnosis has shifted so dramatically.
Mm,
Um, I want you to say just a couple of things about migration law.
mm,
And because that was another very big area of law that we found in this map.
mm.
Um, yeah, can you say a little bit about how that manifests
Yeah,
in the case law?
yeah, absolutely. Thanks, Diona. I'm a criminal lawyer in my kind of teaching and core identity, and I've long worked on and around the criminal law and transmission of disease, particularly HIV. And so, criminal prosecutions in relation to transmission are something I oppose and very focused on. But I also want to say that criminalisation, which is not just the criminal law, occurs through a whole range of different sources, including migration law and indeed refugee and asylum processes. There were quite a lot of migration. I'll call it migration, but it's migration and asylum and refugee processes that came up in this study, in this mapping review. And I think that's important to start to recognise that migration is really now another area of really deep importance for the rights of people living with HIV and indeed those affected by HIV whose family members may be living with HIV. This is something that community has recognised. This is something that the peak bodies have been working on as well as us, because this is clearly a major issue, both legally and also for the response, which people watching this, I'm sure, will know a lot about. Um, uh, the things that came up, apart from the fact that just to know that migration and HIV are an active area of formal court and tribunal processes, is that reading these cases and decisions, it's really clear that where HIV, migration law, and refugee law come together, this creates really, really significant legal and other problems for people that affect their health and well-being, and indeed, I would argue, affect the ability of the kind of national response to be effective to HIV. In our broader work, and indeed in these cases, you can see that migration or claiming asylum um, acts both as its own kind of set of issues, but also as a kind of umbrella in a way for a set of other legal issues that are even clear on the page of a judgment. And indeed in conversations we've had with community members who've migrated. So questions about housing, questions about employment, challenges and disputes about education and training all arise under this banner. So I think, this is to say our long focus on the criminal law in relation to HIV has borne some fruit, but still we've got a way to go. But we see criminalisation occurring and really intense and very active legal challenges and disputes occurring in relation to migration as well, which we, I think, need to pay an equal amount of attention to.
Mm. Thanks, David. And I really just want to emphasize that this is the tip of the iceberg in terms of what this report presents. We reviewed a lot of cases, and there is more detail about these key areas of law in which HIV and HIV related judgments come up. So I would really encourage people to go to our website and find the report and have a read. Um, and yeah, and also to say as you have been gesturing to and saying throughout this conversation that there's a lot more work to be done. This is a map of the legal terrain, and it only gives us a partial view. And we're doing a lot of other things, including currently having conversations with affected people all over Australia. And indeed, we have our national survey in the field as we speak to kind of complete the picture, or not. get a more detailed picture of the legal environment around HIV in Australia. Thank
Mm.
you so much, David.
Thank you, Dion. Pleasure to talk about it. And I agree. I encourage people to have a read of the parts that interest them, and indeed feel free to write to us to, learn more or to participate in our other research as well.
Thanks. And I just wanted to thank you, make a note of thanks also to our other colleagues in the health and law
Mm.
team. Many people contributed to developing and writing this report with us, including Anthea Vogel, Rhys Evans, James Brown, and Hamish Robertson. Also, the Health Plus Law partnership is funded by the Australian Government Department of Health and Aged Care that supports that supports us under the bloodborne viruses and sexually transmissible infections research and data program. Also, a very important thank you to Cara Bruce for assisting us to record and produce this conversation. And again, to read more from HIV and the law in Australia, please go to our website, which is healthpluslaw.org, where you can also download and read our other publications and reports. And there you'll also find another just published review of case law in Australia that looks at the law in a similar way, but around another bloodborne virus, hepatitis B. And I would invite you to join David and I again in the partner webinar to this one to hear a bit more about to hear about the findings from that review, which is a world first mapping of hepatitis B and case law in this way, and what it shows about the legal environment surrounding hepatitis B, which affects a lot of people in Australia. So thank you for tuning in, and goodbye for now.